Hi everybody. Thank you so much for signing up for Rocky Mountain Equality and Martin Law Associates Family Law Workshop. We're here tonight amidst a lot of uncertainty, and it's great that you're here or watching this video at home to plan to protect your families and yourselves. While there may be a lot of uncertainty, there are a lot of opportunities for us to make sure we've got layers of protection that will keep us safe and hopefully deter some of the harmful policies that the current administration is trying to enact. We have a lot to cover tonight, so Jody is going to step up in just a moment and begin going over what they've prepared. We won't be able to get to all questions, and I know that may be disappointing for some. There are multiple reasons for that. One, there's a lot of questions. We all have a lot of questions right now. Specifically, questions around custody and child custody, whether adoptive or otherwise, we're working on doing another workshop just about custody in the coming months because it's a complex issue that would probably need to be done in person so that follow-up questions can be answered at that time. Additionally, questions around documentation are not really in Jody's purview, so we know that there are a lot of folks concerned about passports and gender markers. There are some upcoming events that I want to direct you to in addition to this video, which I will include in the email that this video goes out in. Specifically, we have a drop-in documentation session for trans and non-binary folks happening on March 28th at 6:30 here at Rocky Mountain Equality. We also will have a gender-affirming care for trans youth session, which is geared towards parents of trans youth to talk about options, protections, and rights. That's happening on March 31st at 5:30. I think there may be a hybrid option for that. I'll give you the website in a moment. And not last, and also not least, upcoming trans information session on April 2nd at 6:30. There are more events, resources, and services available on our website, and I really encourage you to check out rmequality.org/events to see the full list of our calendar. We do have supports out there. You are not alone. With that, I'd love to welcome Jody Martin. Jody is a lawyer who has been in Boulder, I'm going off the cuff here, has been in Boulder for a very long time, but not so long, not too long. Jody used to be on the board of directors when Rocky Mountain Equality was out Boulder. And so she has been a member, a fighting advocate and member of our community for quite some time, and she's here to share with us how we can fight for ourselves as well. Thank you, Jody.
Thank you, everyone. Thank you, Kyle. So I'm Jody Martin. My firm here in town is Martin Law Office LLC. We'll jump in a little bit in just a little bit more about me very briefly in just a moment, but just to give you a little kind of additional information early in the video about what we are going to talk about in the video and the meeting is we're going to talk about relationship status. So that would be marriage equality. We'll touch on that a little bit. Then we're also going to talk about parent-child relationships. So how do you strengthen those? How do you protect those? And there I'm talking about things like confirmatory adoption, Parentage Act, and different ways that you can strengthen the parent-child relationship if you are in primarily a same-sex or even a same-sex relationship where one parent is not the birth parent, or even a relationship where it's a member of the trans community and someone else, and the trans member is not the birth parent. And so in other words, how do we fix things to where maybe there's a little more legal protection simply because of the current state of affairs. And then we're also going to talk about estate planning and how you can use those tools to also protect yourself and your family, those you loved, friends, so forth, and have a little bit of control, something that sometimes I think people in our community feel like we don't have, and there's some ways we can do that. So those are sort of the three main areas. So before you start watching the video specifically and go, oh, they're not going to talk about my stuff, just want to give you the headlines so that you can see if maybe we're getting into it. Let's go from there. So These are legal disclaimers. The main thing to know is I am a lawyer, but I'm not giving you legal advice. This is educational purposes only, so no attorney-client relationship is formed, and anything said here, I still recommend you talk to a lawyer about your specific case. So now that you have my little legal disclaimers, we'll go into me. So as mentioned, Jody Martin. I think this says I've been an attorney for over 25 years. Because it's over 28 years now that I've been an attorney. I have been in Boulder specifically since 2012, and since 2012 I've had my own firm here in Boulder. This is a photo of my family. I always put it up no matter if I'm talking to the LGBT community or non-LGBT community, because this is who I am, this is how I approach the law. My family is actually a driving force behind how my firm was designed, why we focus on the issues I focus on, and sort of, as with most of us, the reason for most of the things we do in life. So that's my wife on the, I guess for me, looking at it, the far left, and our daughter who, as you can see at that point, was already taller than we are. That remains the case today as we continue to shrink. So I started my firm in 2012, and one of the primary focuses was how can we address the legal needs of the LGBTQIA community in Colorado. Since that time, as all of you know, the law has continued to morph. We've made progress, we've lost at times, we've made more progress, and now we are in this stage that I'm not really sure what this is. It's in flux for sure. And so that's the nature of my practice. Our client base is probably close to 50-50. 50% of the folks have some connection to the LGBTQI community, and 50% don't. They may be allies, they may not. I'm pretty open with who I am, so they can figure out if my firm's going to be a match or not based on that. All right, so I mentioned the topics that we're going to get into. It's a little out of order. I've moved parental rights up to the second category just so that we can get those talked about following relationship options. So let's talk about relationships. We're in Colorado. Colorado has progressed over the years to where we are currently. Today, somebody can get married, or you can choose to do a civil union. Both of those are options available to you. Or you can have those things occur as a matter of common law. So you can sort of find your way into that without going down to the clerk's office and getting the certificate. We also have, and they are still there, we have a thing called designated beneficiary agreement. And then you can also register as a domestic partnership. Registering as a domestic partnership is pretty much kind of gone out of vogue, if you will. It didn't give you any real rights, other than for most people, it might have made available some insurance options. So for the most part, we see the bottom three or none of those, which means in the eyes of the law in Colorado, you are what we call legal strangers. Even if you've been in a committed relationship for 30 years, if you don't consider yourselves to be in a common law marriage or common law civil union, you are legal strangers in the eyes of the law for purposes of what we're going to talk about today. A designated beneficiary agreement does still exist. It's what we had prior to civil unions. It still exists, and I actually still use it today occasionally for clients that do not want to be married or in a civil union. It gives you certain state level agreements. You can only enter into it with one other person, and neither of you can be married. So if you get married, or if the other party gets married, or if you marry each other or civil unionize, it goes away automatically. But otherwise, the designated beneficiary agreement can give you some additional rights and responsibilities at a state level that you wouldn't have as legal strangers. So anytime somebody says, we don't want to get into a civil union or a marriage, we might look at that and see if it helps things. Civil union, that is giving you the state level benefits of marriage, but none of the federal benefits of marriage. Marriage gives you both state and federal. So those are the different types of options you have. Obviously, also the option of none of the above. Legal impacts. So why do we talk about relationship status? Well, for one thing, the state level impact of getting married is that you have certain priorities under our laws, specifically under our inheritance and probate laws. So for instance, the priority to serve as someone's guardian or conservator goes first to a spouse. You also have some rights to inherit, the ability to be in the room because you're considered next of kin, a right to sue potentially for like wrongful death of your spouse. Also, there are certain parental rights that are tied to the relationship status sometimes, and it provides a divorce process. So it's a process for us to divide the things in the case that the relationship ends. These are legal impacts at the state level. At the federal level, you add to that certain tax implications, certain Social Security benefits and rights that can be very valuable for some people. Family Medical Leave Act and coverage there. So there are a lot of federal laws that have spousal rights and benefits built into them. Those only come with marriage. If you have a civil union, you don't get any of those federal rights and benefits. All right, so those are some legal impacts. You're going to find that as we go, I'm going to move a little quickly. Part of why I'm doing that is I do have a list of some questions I want to make sure we get to, and I want to at least get you kind of the basic information so that we can make sure to address the questions. All right, so the future of marriage. You'll notice that's all the slide says. I don't have an answer for you. I can tell you what some of the concerns are, and I can tell you what the current state of the law is and the state of play if some of the concerns play out potentially. So the question I get pretty much weekly, almost daily sometimes, is what happens to my marriage, or what does it mean if the Supreme Court gets rid of marriage equality? That's the question that is on everybody's mind regarding marriage at least. And that's because we know in at least one opinion, the opinion that overturned Roe v. Wade, one of the judges, justices, specifically said that the right to marriage equality needed to be addressed. So what are we talking about there? Marriage equality, marriage itself has taken really three major legal steps from a federal perspective. 2013, we had the Windsor opinion. That's the Edie Windsor case. That overturned part of DOMA. When it overturned part of DOMA, what that meant was that marriages that were lawful in certain states, such as Miss Windsor's marriage, it was lawful where she lived, and as a result, she was trying to get federal legal rights to her marriage, wanted federal recognition. And what DOMA said was that you couldn't have that. And so in the Windsor case, they overturned DOMA in part, and when they did that, it gave her the tax benefits of her marriage. That's what she was looking for. So that was the first thing. DOMA fell in part in 2013. That was a great ruling, but it didn't give us marriage equality nationwide. That came in 2015 with the Obergefell decision and then some other related cases. But what Obergefell and its related cases did generally was it said we have marriage equality. So marriage equality, what we mean by that is that I could go to any state in the country as a same-sex couple and form a marriage. So we have connections to Oklahoma, we have connections to Kansas, both of which we occasionally go back to. If we had still been living in one of those states, once 2015 hit and the Obergefell decision, we could have gotten married in one of those states. It also means that when we do go to Oklahoma, even though they might not like it, they have to recognize my Colorado marriage. So those are the bits that came from Obergefell. It was a big decision. Since then, at a state level, we have also had a constitutional amendment that happened, if my timing is right, I think it was just last year. I kind of lose track with the way things are today. And Colorado is a state where it's now a constitutional right for a same-sex couple to get married. So we have that built into our Constitution. There are other states who still have laws on the books and constitutional provisions that say marriage is between one man and one woman. And so that's important to know as well, but that's a state level issue. The third federal action that you need to think about came about in 2022, and that's the Respect for Marriage Act. The Respect for Marriage Act passed amazingly through Congress and the Senate, and then was signed by Biden, but it was bipartisan at Congress. And the result of the Respect for Marriage Act is a couple of different things. It completely killed DOMA, so that is theoretically completely gone. But the keys for our discussion are, it finds it, or makes it, so that the place of celebration controls federal recognition of your marriage. Why is that important? If you yourself or talk to some of your other friends, you will find that there are a lot of folks in our community that have gone to other states to get married. or even countries, because Colorado didn't have it until theoretically 2015. We can talk about the history with Cleveland Rorix and other things, but for the most part, for all of us, really wasn't available until 15. And so what happens is these people have, or the Respect for Marriage says, if you went to, say, New York and got married when it was legal there, that it has to be recognized even in your home state. So if that's Oklahoma and they don't recognize it anymore, it doesn't matter. Under Respect for Marriage, they have to recognize it. It also says that the courts across the nation have to give full faith and credit to certain orders. That includes marriages, those aren't orders, but it includes marriages. It also includes adoption decrees, and that's going to become important here in a minute when we talk about parentage. So it's important to know about the Respect for Marriage, because that's not what the Supreme Court could overturn. They could overturn Obergefell. If they overturn Obergefell, it doesn't mean your marriage goes away. What it means is that they have overturned the Supreme Court case that requires recognition nationwide. But the Respect for Marriage Act then kicks in, and that act is specifically going to give you certain protections. So if you were married in, say, Oklahoma, there's a chance that you could have a problem with your marriage being recognized in Oklahoma based on their laws. Again, picking on a state that I'm familiar with and not a big fan of, to be honest. But if you were married in Colorado and you have moved to Texas, and Texas doesn't want to recognize your marriage, the Respect for Marriage Act says they don't have that right. And it also means that your federal tax benefits aren't going to go away. So what would happen if they overturned Obergefell is that in these states that don't like marriage, or that have laws opposing same-sex marriage, you will see marriages stop. So what's going to happen? Just like with other things, we're going to see travelers, right? People traveling to states like Colorado to get their marriage and then go back to their hate state and be protected at a federal level and have some other protections. So it's a long-winded answer for something I said I can't tell you much, but that's some of the highlights that you need to know. So if you're currently married, you have a marriage, you will have a marriage. That's not going to go away. They can't take it away. Are they going to mess with things? Sure, I think they will try to mess with things. But the Respect for Marriage Act is the law right now, and that's where we need to kind of focus certain things when we're worried about some of the folks at the Supreme Court. All right, if you're not married, if you live in Colorado, your right to marry will continue even if they overturn Obergefell. If you plan to move to Texas or Oklahoma, you might evaluate, if you're not currently married, what you want to do with that regard. It's not my job to encourage people to get married or to tell you that that's what everybody needs to do, but evaluate your options. Okay, moving on from marriage. Parental status. When I talk about parental status, that means a lot legally. So what happens under Colorado law, and most of you that have kids that have had them probably, let's say, since 2015 at least, you probably, even if you've done nothing else, you are probably both on the birth certificate. Colorado and most states have a law that essentially says if we are married, which in Colorado would include in a civil union, we are both presumed to be the parent of the child born in that marriage or civil union. Because of that presumption, in Colorado, two people go into the hospital, opposite sex or same sex or transgender and not transgender, it doesn't matter. Two people go into the hospital, they have that baby, they are going to get paperwork and they fill it out as both of them being the parents, and that's what's going to happen on the birth certificate. So you're both on the birth certificate, but the birth certificate is not the end-all be-all. A birth certificate is an administrative document. Administrative documents are subject to being essentially rebutted. They are subject to challenge. So an administrative document gives you a presumption of parentage, and it confirms that in paperwork, but it is not the end-all be-all. So with an opposite sex couple, how does that play out, where they are both able to contribute to the DNA of a child? What happens there is, and I've known people where this has occurred, they go in, they're married, they have the baby, the belief of the husband in that scenario is this is his child, they're both on the birth certificate, they rock along a little ways, and then suddenly maybe there's domestic issues, maybe there's some other issue, and husband is like, I don't really think that's my child. Or the wife in the fit of rage or a fight says it's not your child, or some other fella shows up at the door and says that's my child. Those disputes are resolved in opposite sex couples that can contribute DNA. They're resolved by DNA testing. That does not work for our community in all cases. So what we do is we need to use things to prove our parentage to overcome the presumption. So I have a birth certificate, it creates a presumption of parentage, but if there's a challenge, how am I going to defend that? I was not the genetic donor for our daughter. So without something else, how do I prove my parentage if our relationship ends, or if my wife died and a family member came in and contested my relationship? How do I show that tie? We do that by using other legal tools that are available to us. Those options vary by state. They can vary based on relationship status as well. The risk talked about here is talking about the risk if we don't do something. So in Colorado, our options, if we're not married or not in a civil union, we can use confirmatory adoption, which we'll talk about in a moment. And that's fact specific. There are instances where it won't apply to this couple, but most of the couples that come in to do this, we can get them inside confirmatory adoption currently. Otherwise, we might be looking at a second parent adoption. That is a more intense adoption process. That's going to require a background check of the what I'm going to call the non-birth parent, for lack of better lingo. It's going to require a background check, so CBI, FBI. It's going to require a home study, which can be honestly extremely offensive in these situations. You can also try to establish your parentage under a Uniform Parentage Act. Either way, what you're doing here in these top three is getting an order from a judge. Remember when we talked about the Respect for Marriage Act, I mentioned that courts nationwide have to give full faith and credit to those orders such as adoption decrees. And so we're trying to get that locked in so that if we're in one of those states, again, I'm going to pick on Oklahoma, we know that we have something that we can fight with. There's also a voluntary acknowledgement of parentage form. There's I think an image in the slides on that. That is a specific type of form that you can use in Colorado that confirms your parentage. It doesn't give you a court order, it doesn't give you an adoption decree, but it does carry some legal weight, specifically in Colorado, so it is another option that doesn't involve kind of a court process, so theoretically should be lower in cost is the idea. All right, if we are married or in a civil union, again, we definitely would probably be on the birth certificate unless we say we don't want to be. Confirmatory adoption, which I'm about to talk about, that VAP form, or parentage through UPA. Let's talk about confirmatory adoption for a minute. I've kind of said I'd put it on hold. Confirmatory adoption is I call it a simplified adoption process. It was specifically built in Colorado for our families. It was designed for this. It actually was triggered by in part by some cases that I was tied into and another attorney colleague. And what happens with confirmatory adoption is it is designed for couples where artificial reproduction was involved, and so there is not a third party with a legal claim to parentage. And we are either in a civil union, a marriage, or we can establish parentage through what I'm just going to generically call the UPA. In other words, we can show like we've taken the child into our home and raised them as ours, and the intent is for us to be a parent. So the confirmatory adoption process is a paper adoption. What I mean by that is it is about doing the paperwork and filing it with the court and getting your decree. You are not going to be required to do a background check. There's no FBI, no CBI, no fingerprints. There's no home study. And the law specifically says the court does not have authority to order those things. So if you file a confirmatory adoption and you meet the standards, they can't order that. It also says the court cannot require a hearing. Second parent adoption, they'll require a hearing. Step parent adoption, which isn't on this list because they won't apply it to us anymore. That's kind of what led to confirmatories coming along. that process also requires a hearing. So here, when we file these, clients, literally, my process is, they get me the stuff, we're gonna have them a set of draft documents within 2 business days. They're gonna be able to sign them electronically, and we're gonna get it filed as soon as it's fully signed. And the law says the judge has to give us an order within 30 days. Some judges have maybe missed that deadline, but vacations happen, we'll assume that's why. Most judges today, I'm getting them back anywhere from 1 week, maybe 2.5 weeks, depending on the county. And I have filed them in every county. I mean, even in, not every county obviously, but even in the counties that we all worry about, I have filed them and they come back, granted. But if you're worried, you can file them in any county as long as you live in Colorado. It can also be used by someone who the child and the birth certificate is from Colorado, but you have relocated out of state. It allows you to file it still in Colorado. So this is a very simplified, and again, I don't like to use that word, but it is a simplified process. But at the end of the process, you have an adoption decree, the same as if you'd done a harder process. And that adoption decree carries full faith and credit. So if your work transfers you to Oklahoma, you have an adoption decree, and that carries full faith and credit under our law. And that has raised you from this administrative document of the birth certificate to a more secure parent-child relationship. And so as people contact me worried about how do we protect our kids, how do we protect our family, one of the first things I recommend, whether your kids are 15 or 5 months, look at the confirmatory adoption. We do it at a very reduced cost to help families right now, and I'm always happy to talk to people about it. You can try to do it on your own as well, but that's one of the big things out there. Use our tools. It is an amazing law in Colorado. Okay, I'm going to go to the next slide. Voluntary acknowledgements of parentage. This is who has the VAP form. There are other states besides us that recognize VAPs. So, you can, again, that is something you can use. It definitely is worth looking into if you're not going to do anything else. The other thing too, before I forget, occasionally folks will contact me, and under the old processes that we were using before we had confirmatory adoption, they did a UPA. So they got a parentage order, which is a court order, and they have that, and they want to know if they can do anything else. If you have a parentage order, you can follow it up with a confirmatory adoption, just so you now have an adoption decree rather than a order. And in some states, it makes a difference because they might not have parentage orders, and so here you have an adoption decree. Do you have to do that? I would argue legally no, but it's like the gold standard, so to speak, versus, I don't know, whatever's slightly less than a gold standard. Not gonna dog the Parentage Act because we had to use that for many years. So, all right. Adoption in other states. There's a little bit of information here. There's some sort of second parent or step parent adoption process in every state. Whether they will apply it to your family is a question. There are states that have actively resisted, again, I'll pick on Oklahoma, actively resisted allowing same-sex families to go through adoption. So just be aware that it just depends what state you're in. All right, and the confirmatory adoption process, last I checked, this was the list of states that had it. There could be, I think that's probably about a year old. There might be another 1 or 2 out there. Those are ones that offer those. So if you have friends or connections in one of those states, it is very similar. Ours is built basically on the California system. So yeah.